Welcome back to the deep dive. We're here to give you that shortcut, that distilled knowledge you need on complex topics. Today, we are really getting into a cornerstone of South African governance, the Promotion of Access to Information Act, number 2 of 2000. You probably know it as PAIA.
Exactly. And PAIA, it's much more than just some legal checkbox. It really is the engine driving our constitutional right to know, to access information.
So our goal today, give you a clear roadmap. We want to explain PII's purpose, how it's structured, especially the split between government and private companies, and what happens when you actually try to use it, including the appeals.
Absolutely. We need to cover the practical side, the friction points. It's relevant whether you're just a citizen trying to find out about a local council decision or, a legal team needing specific records.
Okay, so let's set the scene. Where does PAIA actually come from?
Well, fundamentally, it comes from the Constitution. Section 32 basically demanded this act exist. It enshrines the right of access to information.
Yeah.
And it guarantees two specific things. First, access to any information held by the state. That's Section 32(1)A.
Any information. That sounds broad.
It is broad, within limits we'll discuss. But then there's Section 32(1)B, which covers information held by another person, think private companies or individuals.
Ah, okay.
But here's the key difference. For private bodies, you can only access information that is required for the exercise or protection of any rights. It's a stricter test.
That distinction seems crucial, and the history behind it. Why was this seen as so necessary?
The Act's own preamble tells you why. It explicitly acknowledges that the old system, pre-1994, created a, and I quote, secretive and unresponsive culture.
In both government and private sectors.
Yes, both. And this secrecy, it allowed for abuse of power. So PIIA's core goal, its reason for being, is transparency and accountability.
Makes sense. And it's been around since 2000, but it gets updated.
That's right. Assented to February 2nd, 2000, but it's constantly tweaked. The version we're looking at includes updates right up to October 11th, 2024. It has to adapt, especially with things like digital information.
Okay, let's get into the mechanics. If PAIA is about accessing information, what kind of information are we talking about? What counts as a record?
Good question. The definition is deliberately wide. A record is basically any recorded information.
Like paper documents, emails?
Yep. Paper, digital files, emails, videos, even text messages. Doesn't matter what form it's in or who created it.
So if a government department has a report written by a consultant, that counts?
Absolutely. The key is whether it's in the possession or under the control of that body. Doesn't matter if they made it or when it was made.
Okay, that broad definition is important. Now, you mentioned PAIA treat public and private bodies differently. Let's unpack that structure.
Right. So the Act is literally structured that way. Part 2 deals with public bodies.
Which are?
Think government departments, national, provincial, local, municipalities, state-owned enterprises, basically any organ of state.
And how easy is it to get info from them?
Well, Section 11 says access is the default. If you follow the correct procedure for requesting the information, they must give it to you, unless a specific ground for refusal applies.
So the starting point is, yes, you can have it.
Pretty much. Your request goes to someone called the information officer in that public body. They handle the process.
Okay, that's part 2. What about part 3, private bodies?
Part 3 covers private bodies. That could be a big corporation, a small business run as a partnership, a nonprofit, even an individual acting in a business capacity.
And you said the rule is different here.
Massively different. Under Section 50, if you want a record from a private body, you, the requester, have to show that the record is required for the exercise or protection of any rights.
Required, not just helpful or interesting.
Exactly. Required means necessary, essential. It's a significant hurdle. You can't just go fishing for information.
So, give me an example. If I think a company unfairly dismissed me, I might require their internal HR records relating to my dismissal to protect my right to fair labor practices.
Precisely. You need to link the record directly to a specific right you're trying to exercise or protect. If you can't show that link, your request to a private body will likely fail.
Yeah.
It stops PAIA being used for, say, industrial espionage or just general snooping.
That makes sense. It's balancing transparency with, well, legitimate private interests.
It is.
So whether it's the information officer for a public body or the head of a private body, once they get a request, how long do they have?
The standard timeline is 30 days. They have 30 days to decide whether to grant or refuse the request and let you know.
And if it's complicated?
They can extend that once for another 30 days, but they have to tell you why. Maybe they need to find old records or consult with the third party mentioned in the documents.
What if they just don't respond?
Silence is treated as a refusal. If the deadline passes and you've heard nothing, it's considered a deemed refusal, and that triggers your right to take the next step, like lodging a complaint.
Okay. Before we even get to requests, these bodies have homework to do, right? They need to be ready.
Yes, proactive disclosure is key. Both public and private bodies have obligations here, centered around creating and publishing a PAIA manual.
A manual. What's in that?
For public bodies, Section 14 says the manual must be in at least 3 official languages. It's like a guide to the organization.
So it describes their structure, what they do.
Exactly. Their functions, the types or categories of records they hold, contact details for the information officer, and importantly, information on how to make a request and what remedies are available if you're refused.
And private bodies.
They also need a manual under Section 51. It might be less extensive, but it still needs to cover key details like contact information and a description of the records they hold. But here's a crucial update.
I think I know where this is going. PAIA, the Protection of Personal Information Act.
You got it. The two acts are now deeply intertwined. Since the information regulator, which was set up by PAIA, took over responsibility for PIA as well back in June 2021.
Right. They handle both now.
The PII manuals for both public and private bodies must now also include specific information required by PAIA.
Like what?
Things like the purpose for which the body processes personal information, descriptions of the categories of data subjects, details about any cross-border transfers of personal info, and importantly, a description of the security measures they have in place to protect that data.
Wow. So the PII manual isn't just about getting information anymore. It's also about telling you how they protect personal information.
Precisely. It creates a more unified framework for data governance. The information regulator is central to this. They also update the official PIA guide for users, and importantly, they have a duty under Section 83 to run educational programs.
To help people understand their rights.
Yes, especially focusing on disadvantaged communities, to make sure this right to information is practical, not just theoretical.
Okay, so we know how to ask, and we know bodies have to prepare. But access isn't guaranteed. Let's talk about refusals. Why might access be denied?
PAIA accepts that the right isn't absolute. The preamble itself says limitations must be reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. That's the constitutional test.
So there are legitimate reasons to say no, and the Act distinguishes between mandatory and discretionary refusals.
Correct. Mandatory grounds mean the information officer or head must refuse access unless an exception like the public interest override applies.
What are the big mandatory ones?
Privacy is a major one. Protecting the privacy of a third party, another actual person, even if they're deceased, is mandatory under Sections 34 and 63.
So you can't just ask for someone else's private emails or medical records.
Generally, no. Another big one is protecting commercial confidentiality. Sections 36 and 64 say access must be refused if it involves trade secrets of a third party or financial, commercial, scientific, or technical information where disclosure would likely cause harm to their commercial or financial interests.
Protecting businesses from rivals getting their secrets. Makes sense. What else is mandatory?
Records privileged from production and legal proceedings like lawyer-client communications are also protected. That's Section 40 and 67.
Okay, those are the must-refuse grounds. What about may refuse, where the official has a choice?
This is where judgment comes in. For instance, while endangering someone's life or safety is a mandatory refusal, the official may also refuse if disclosure could reasonably be expected to prejudice or impair the security of buildings, systems, or methods used for protecting public safety. Think security plans or specific policing techniques.
So a bit more nuanced. What about just, well, annoying requests?
Section 45. An official may refuse a request if it's manifestly frivolous or vexatious, or if fulfilling it would involve a substantial and unreasonable diversion of resources.
Now, that sounds like it could be misused. How do you stop a department just calling any difficult request frivolous?
That's a real concern, and it does get argued over. The key word is manifestly. It has to be obviously, plainly frivolous or intended to harass. And the unreasonable diversion of resources has to be substantial. It can't just be because it's inconvenient. The idea is to protect public bodies from abuse, not to shield them from scrutiny. Ultimately, if you disagree, this is something you can take up on appeal or complaint.
Good to know there's a check on that. So if they do refuse, what does the refusal notice have to say?
It can't just be a simple no. Section 25(3)(b) is clear. It must state adequate reasons for the refusal, and critically, it must specify which provisions of PII they are relying on.
But they don't reveal the content they're refusing.
No, the notice must exclude references to the actual content of the withheld record to maintain that confidentiality.
And there's this important idea, severability. What's that?
Very important. Sections 28 and 59. If a record contains some information that must be refused, like a trade secret, but also other information that is releasable, the official must separate the sensitive part and disclose the rest.
So they redact the confidential bits but give you everything else.
Exactly. The principle is maximum disclosure. Cut out only what is absolutely necessary according to the refusal grounds.
Okay, now let's get to maybe the most powerful part of PAIA, the public interest override.
Yes, sections 46 and 70. This is the ultimate trump card. It says access must be granted even if a mandatory refusal ground like privacy or trade secrets applies, if certain conditions are met.
What are the conditions?
Two things need to be true. First, the disclosure must reveal evidence of either a substantial contravention of the law or an imminent and serious public safety or environmental risk.
High-stakes stuff, like proof of major corruption or that a factory is about to cause a toxic spill.
Exactly. And the second condition is that the public interest in disclosing that information must clearly outweigh the harm that the refusal ground was trying to prevent, like harm to privacy or commercial interests.
So it's a balancing act, but tilted towards disclosure when the risk or wrongdoing is serious enough?
Correct. It ensures that confidentiality shields can't be used to cover up major public dangers or illegal acts.
Now, what if the records I want involve someone else's information, a third party?
PAIA has a process for that. Under sections 47 and 71, if the request involves a third party's personal or commercial information, the official must take reasonable steps to inform that third party.
Give them a heads up.
Yes, usually within 21 days. The third party then gets a chance, typically another 21 days, to either consent to the disclosure or make representations explaining why they think it should be refused based on PAIA's grounds.
So they get to argue their case before their info is released. Seems fair.
It ensures procedural fairness for those whose data might be affected.
Okay, let's say I've made my request, I've waited, and I get a refusal. Or maybe a deemed refusal because they missed the deadline. What do I do next? I can't just go straight to court, right?
No, generally you can't. There's a mandatory path you usually have to follow. It's kind of a three-step potential process.
Step 1.
Step 1 only applies to certain public bodies listed in the Act. For those, you first lodge an internal appeal against the information officer's decision. This goes to the relevant authority within that same public body.
Okay, an internal review first. But what if it's a private body or a public body where internal appeals don't apply, or I lose the internal appeal?
Then you move to step 2, which is now mandatory before court for almost all decisions. You must lodge a complaint with the information regulator.
The same regulator that handles PAIA.
That's the one. Section 77A covers this. You generally have 180 days from the decision or deemed refusal to submit your complaint form.
What does the regulator do?
They can investigate, they can try to mediate or negotiate a settlement between you and the body. If that fails, they can make a determination and issue an enforcement notice ordering the body to take specific action, like releasing the record.
And that enforcement notice has teeth.
It does. Ignoring an enforcement notice from the regulator is a criminal offense under Section 77K. Penalties can include fines or even imprisonment.
So the regulator step is designed to resolve things without clogging up the courts.
Exactly. It acts as a crucial filter and dispute resolution mechanism.
But if the regulator process doesn't resolve it in my favor, or the body ignores the notice and challenges it, then what?
Then you finally reach step 3, an application to court. This is usually the High Court, though certain magistrates' courts also have jurisdiction now, Section 78.
And in court, who has to prove their case?
This is a key advantage for the requester. Section 81 puts the burden of proof squarely on the body that refused access. They had to convince the court that their refusal was justified under PAIA.
Not the other way around. That seems important.
Very. And the court has broad powers under Section 82. It can make any order that's just and equitable, including confirming, varying, or setting aside the original decision, ordering access, or even granting compensation.
And just to underscore the seriousness, there are penalties for deliberately blocking access.
Yes. Section 90 makes it a serious offense to destroy, damage, alter, conceal, or falsify a record with the intent to deny a right of access under PAIA. That can lead to a fine or imprisonment for up to 2 years.
So the system has mechanisms to protect the integrity of the right to information.
Definitely. It underlines that this isn't just optional, it's a fundamental right backed by enforcement powers. PAIA is really designed, as Section 9 states, to promote transparency, accountability, and effective governance. It empowers citizens.
Okay, so wrapping this up, PAIA is this vital piece of legislation, born from the Constitution, that tries to balance the public's right to know against necessary protections for things like privacy and commercial secrets.
It's a constant balancing act.
Which brings us to our final thought for you, our listener, especially if you're diving deep into this, perhaps as a law student or just an engaged citizen. PAIA really pivots on this concept of the public interest, particularly that override clause we discussed.
That's Sections 46 and 70 again.
Right. Think about it. The law says you must disclose information, overriding even strong confidentiality claims, if it reveals serious illegality or public danger, and the public interest outweighs the harm of disclosure. How effectively can any system, whether it's the regulator or a court, truly weigh something as sensitive as individual privacy against something as potentially vast, yet sometimes abstract, as public safety or preventing a contravention of law?
It's not a simple calculation.
Not at all. It suggests that PIA isn't just a set of rules, but requires ongoing critical judgment and, frankly, active use by people like you to test its limits and ensure it actually delivers on that promise of transparency and accountability in practice.
That tension, that need for constant application and interpretation, is precisely what keeps this law relevant and vital in our democracy.
Couldn't agree more. Stay informed, keep questioning, and we'll catch you on the next deep dive.